Good morning, everyone. Welcome to Banking on Women, hosted by me, Sarah Sabastro. Good morning, everyone. Welcome to Bank on Women, hosted by me, Sarah Sabastro, CEO of Biz Credit Builds. And I am here today because I wanted to talk to you about financial literacy on the business side. If you haven't already done so, please follow at Biz Credit Builds on Facebook. And definitely, if you haven't already joined this network, you really should. I am going to have a special host joining us shortly. And I wanted to talk about some things that we kind of forget about when we're talking about business and contractual agreements and trademarking. So our special guest is going to be Dana Blue. And if you haven't already done so, stop what you're doing and join. She is still dope. I am here every Friday from 10 to 11 Eastern Standard Time. Please join us on a weekly basis. Share this on your Facebook. Share this on your other social media outlets. We'd love to have you. So again, I'm going to jump right in because we got a lot of information to cover. If you haven't already done so, She Is Still Dope. Go on over to sheisstilldope.com and join our network of women doing all kind of beautiful things all over the world. And again, I'm Sarah, your host. I'm the CEO of Biz Credit Builds. Join bizcreditbuilds.com or my Facebook group, Biz Credit Builds with an S. We'd love to have you. So I wanted to talk about essential contracts for small and growing businesses. So oftentimes when we think about contractual agreements or we think about going into business, we get an EIN, we get a business license, and we think we're free and clear of all kind of things. So I want to summarize some key contracts for small and growing businesses. These contracts are needed and are crucial to operate your business legally and to be successful. You don't want to be held liable for things that are beyond your control. So the first thing I want to address is employment offer letters, right? One of the best ways to protect your business from legal liability and misunderstanding is when an employee, when you make them a legal offer, you should definitely address them with a formal offer letter. And in that offer letter, you need to put some key things that protect you as their boss and the owner. The employee should then be required to sign that letter, evidencing the scope of your employment relationship between two parties. And then it literally will go into not only what that job is, what the responsibilities of that job is, but also salary, benefits, time off, at will, confidentiality statement, and some guidelines so that if you guys ever have to if that person ever has to separate from employment, you already know what the scope, or you're protected in some way legally. There are several people who get into disputes that this particular offer letter that they physically sign will be able to help when you're handling disputes like or binding arbitration. And arbitration is just you going to court and kind of defending yourself as an employer, or workers' compensation disputes, and even unemployment. So it's just super important that whenever you hire somebody that you have this in place. Confidentiality and invention assignment agreements. This is super important. Employees have access to your company's secret formula, right? When they're working for you, and your confidential information. Moreover, many businesses expect their employees to act ethically and come up with ideas, products, business strategies, inventions, processes to make sure that your employee keeps your proprietary information confidential and your company's information confidential and your secret sauce to the way that you do things. I require all of my employees to sign a confidentiality agreement and an invention assignment agreement that just basically says that you cannot share what we do here, my ideas, my business strategies, my work products, my vendors, who I utilize, the scope of my work, whether it's developed by you, the employee that works for me, or me. So if you expect to have venture capitalists or other professional investors in your company, you want to keep their information too confidential, because that's nobody's business. So yeah, it's super important that you keep these things in place. Another one, you want to avoid any misunderstanding and undue liability. So ideally, this agreement would give you, if they were to leave you and go do this somewhere else, you can put a statement in there that says, hey, I fix credit, and you can't go fix credit for anyone else for the next 2 years, because you want to protect your business. You can't go and start another business credit business, or you can't go do this service or do this somewhere else for a specific amount of time. I think that oftentimes we get that misconstrued, and we do ourselves a disservice because people end up leaving us, and next thing you know, they opening up a business doing the same thing that you do. So it's just super, super important. Another thing is service contracts, right? Most of us provide services. So if your company provides a professional services as opposed to selling a particular product, it needs to have its own good standard form of service contracts, right? Which can be labeled many things, including an agreement for professional services. This type of agreement carries key terms that specifically spell out your responsibilities versus liabilities. In there, you want to avoid, again, any misunderstanding due to undue liability. Ideally, this gives you the flexibility in completing services. It lists the fee for the job, specific a statement of work, what that service includes, limitations, a good, strong sales contract basically lays out the price, terms, agreements, conditions, the sale of good equipments or products. You gotta basically lay it out. It's your responsibility because you're the one that provides the actual service. And then once you do that, that actual sales contract can take form of the fine print in order of a form or an invoice. And in there, you need to put your policy, whether there's no refunds, price adjustments, taxes, warranties, and disclaimers, right? Because you definitely want to cover yourself in the form of if something happens and you need to cover yourself, or if someone does a chargeback, you can pull out the sales contract and always have this client or the customer electronically sign it or physically sign it, because this is going to be key if someone were to do a chargeback or anything like that. Lastly, confidentiality agreements, right? And there's so many other contracts that I haven't gone over, but these are the three most important to me. There has been numerous instances arise where you want to share confidential or proprietary information with another party, and you may want to get their their idea on your new product or something that you're about to launch, or an idea, and you may want to show this information to get them interested in doing a deal with you or investing in your company or even working on some strategic agreement together. Producing an agreement to prevent that other person that you're sharing this information with from sharing that with anyone else or taking your idea. It's always important that you have an NDA in place. And this is referred to as a non-disclosure agreement. This provides the recipient of this proprietary information to hold on to that information in strict confidence, and they legally cannot use this information for the purpose of evaluating or entering in a business relationship with anyone else doing that same thing. So it's always super important that you enter into an agreement legally, make them sign so that's legally binding before you disclose any of your ideas or information or any information when it comes to business at all. A good confidentiality agreement lays out the recipient's confidential obligations and exclusions from confidentiality, how long that confidentiality obligation lasts, the limitations on that information, and the right to disclose party to seek like a relief to stop the other side from disclosing this information to anyone else. So those things are super, super, super important. And sometimes we forget about that because we want to literally, because this is my friend, or this is my business colleague, or this is someone that I've known for a long time. They will never do this to me. So keep in mind that we need to take the personal out of it, and we definitely need to be conscientious of what we share to other people, because without an NDA in place, they can do whatever they want with their idea. It's not legally your idea. So just keep that in mind. Now, there are other things like website terms of user agreements, copyright protections, letters of intent, stock purchase agreements, leases, a business lease for your retail space. I can't tell you how many people have gotten a business lease, and once they get into that agreement or business lease, they do not oblige by those agreements, or they want to reconstruct that space, and the landlord is like, you can't do that. So they want to then sublease it to someone else, and you can't do that legally. So I mean, it's important that we read and understand these things. Loan and agreements, right? So loan agreements usually outlie with that bank or financial institution. It's basically like the borrower or whoever that person is getting that loan, it outlines all the key issues, literally the terms, the finance rate, the interest rate, how long. So it's important that, you guys are making sure that you have all of that in order. So I know that I went over a whole lot of information, but I think it's super, super, super important that you guys have these business forms and agreements in place before you decide to do anything on the legal side, down to hiring somebody or to sharing an idea or to training people. It's super, 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 super important that you guys have all of these things in place, because what happens is that the minute that you don't have these things in place, someone can essentially take your idea, make money off of it, and then you legally can't pursue them to address what they did or to serve them with something stating that, there's some liability that you need to take in concerns to this. And when it comes to court, these contracts, the first thing they're going to ask you, a judge or a master or even a lawyer or an attorney on the business side, the first thing that they're going to ask you is essentially, did you have an agreement in place? And a lot of people have agreements in place, but they're not electronically signed or physically signed. So keep in mind that a signature is also key to holding these contracts in place. Now, the basic elements of an agreement or a legally enforceable contract are mutual assent. Basically, that contract has to be accepted, right? So if I offer you a contract and that other person doesn't sign it or agree to it, then that's not a legal contract. So keep in mind that there are 4 requirements to make a contract legally enforceable. So the mutual assent, right? The acceptance, the consideration, right? It can't have terms that are crazy terms, because they're going to, when you get to court, if those terms are crazy, they're going to basically make you assume some of that responsibility legally. So you got to make sure that they have adequate considerations in there. And then the legality, right? That signature, right? In there, you need to state this is a legally binding contract. And you need to put in there what those legally enforceable consequences are, so that when something happens, you can essentially pursue those things legally. So I'm going to give you 10 tips for making solid business contracts and agreements, right? The first one is get it in writing, right? The second one is keep it simple. I can't tell you I can't tell you how many times I get people who add things onto a contract because they just literally copy and paste it from online. And then when something happens, it does them a disservice because they done copied and pasted a contract. They didn't have anyone legally or a lawyer look over it. And it essentially does them a disservice when they go to court. Dealing with the right person. Keep in mind that you should definitely make sure you're dealing with the right person. Spell out all the details. Specify the payment obligations. Agree on circumstances that terminate the contract. I always put in writing literally that I can terminate a contract at any time, because you definitely don't want it to have things in there where they have to do something specific and you guys can not get along legally or on a personal side, and some things could have happened outside of that contract that just makes you feel not right, and if you want to jump ship, you should be able at any time. Agree on a way to resolve disputes. That's important. Pick a state or a law to govern the contract. And then number 10, keep it confidential. All right. So as I promised, I have a special guest here today. Her name is Dana Blue. She'll be on any minute. Hi, Dana.
Hello. Good morning. Happy Friday.
Good morning. Welcome. So Dana is a seasoned business attorney. Specifically, she trademarks. So she's like the trademark queen. And I wanted to bring her on because and she'll be on most likely next week also. So this is more of an informal conversation. So we just went over, Dana, some contracts that are super important to have. Yep. And I essentially just went through some specifics. I also talked about the contracts that I went over in specific were employment and offer letters when you're hiring somebody, confidentiality and assignment agreements, and service contracts. And then the importance of confidentiality, the NDA, putting the NDA in place. But I wanted to give you guys a little background on how me and Dana met, right? She handles my trademarking. I have several businesses. She also handles my nonprofit. And I have come to Dana. The way that I came into my relationship with Dana was I got into some legal trouble, right? So I own Biz Credit Builds, and that's my trademark, right? And I do several things that I'm legally able to do with Biz Credit Builds. And because Dana did my trademark, no one else can do those things or utilize my name without my permission legally. So it was about a year and a half ago. I was specifically, I didn't even know, but I was doing loans like I always do. And someone was acting on my behalf. They opened up Biz Credit Builds Gmail. And I had a client just call me out of the blue, and they were like, "You did my loan and you charged me 40% of my loan amount." First of all, it's unethical to do that. So it caught me a little off guard. My secretary got the phone call first, and then I got it later. And the gentleman was super upset and stated that he specifically spoke to me. So many of you know, if you call my office, you don't ever speak to me personally. It's always one of my loan processors or my admin that you speak to. So I was definitely like, "Sir, I can assure you, you didn't speak to me because I would have known." He was like, "But your email stated that it was signed with your name." I was like, "Sir, are you able to forward me that email?" So I gave him my info at Biz Credit Build's email address, right? And he was like, "Well, you emailed me and I sent my documents to a Gmail." "Sir, I don't have a Gmail." So someone had created a Biz Credit Builds at gmail.com, and I didn't know. At the time, this person was using a payroll, one of the payroll companies that I partner with. And this is a small world, so all of us know each other. And Dana just happened to be talking to the payroll person, and he was like, "Hey, Sarah," he was like, "I received a notification from somebody wanting payroll services from a Biz Credit Builds at Gmail." And Dana was like, "I'm her business attorney. She doesn't have any Gmail." So they right away contacted me, and I started freaking out. Right, Dana?
Yeah, you did. Rightfully so, though. Rightfully so.
I was like, "Oh my God, somebody is using my information and I don't know who." So I contacted Gmail immediately. Gmail, basically there's an FBI task force. I didn't know this, that essentially I had to write a complaint about. I had to send my copyright information and my business licenses. And I was like, "Listen, I don't know how many people this person has done business acting like me. So we need to contact them." They emailed everybody right away and let them know that, please don't send over any information. This email is no longer going to work. And I essentially physically called them personally and apologize and try to remediate the situation.
Right.
And they essentially, their task force did their thing. But they shut down the email address immediately. And then they assigned me privilege to it because and all rights to it because I own that trademark. So nobody can create that email in the future. But if I didn't have her save my life with this trademark, I would have definitely been in some legal trouble. what that person did was unethical, and it was a former employee of mine. So
That part, right?
you
So
have to be
that
very careful.
Yep. And that ties in what you were talking about earlier with having contracts on your employees and your contractors for, your trade secrets and non-disclosure of particular information that is specialized for your company. Most times when people think about protecting their business, they think about, trademark and copyright, and but they don't think about those contracts. Those contracts are crucial to have with people that you do business with, whether they are a freelancer, a contractor, or someone you hire, because oftentimes these are people that you end up trusting, that you end up giving access to very sensitive information. And you just want to make sure that you're protecting your ideas, your profits, your passions, your other people, because, you have other employees that you have to protect. You have you want to maintain the health of your business so you can continue to, hire and pay people and not have any type of business disruption because you have a disgruntled employee, or you have someone that leaves and, decides to change passwords or do something malicious. You want to be able to have recourse to either, sue them or pursue them in some manner that's going to get you retribution.
And that's the key, right? The retribution part. I think oftentimes we say, forget it. I've been doing this forever. I can start over. No, like legally.
Or the headache. It's oftentimes a headache. And, people just want to, kind of say, well, I learned from the situation and move forward. But oftentimes you can't recoup your losses. You end up taking steps back and going into downward spirals that aren't necessary and that you could have prevented had you been a bit more proactive with the proper contracts and even screening in some cases. I don't think a lot of new business owners, we don't really necessarily do all the proper screening when we're looking at who we want to work with and bring onto our teams. So that I know you do a lot of screening, Sarah. I know that's your
Listen, it just taught me, like, I'm just not for everybody. I've learned to put some things in place, but like any business owner, those are things that I had to learn through Dana. I think for me,
experience, unfortunately, right?
Yeah. So literally, most things I discuss with her before I even take on. If I have a legally binding contract, Dana, bill me for 2 hours. I need you to look at this contract and give me your feedback. Should I remove some things? Should I add on some things?
Absolutely. Let's talk about that for a quick second, because I really want to dispel the myth that working with an attorney is, an exorbitant, unaffordable cost. There's several different ways that you can have contracts reviewed or drafted that are not exorbitant, but it is so important to have an attorney review your contracts at a minimum. I'm not going to be naive and act like people aren't pulling templates offline. Okay.
You were talking about that earlier because
and
that template may not serve you. I learned that from Dana. Like, please do not copy and paste, because some of those things in there may do you a disservice.
Absolutely. And I don't have an issue with templates. I mean, we all use templates. Once I create a contract, when I pour, 12, 20 hours into one particular contract, I reuse it. That's my template, right? So everyone uses templates. But what is really important to understand is that if you don't have the legal knowledge or background, you don't know how that contract operates in other jurisdictions with their state law. You don't know. Sometimes folks don't even know the true nature of the relationship between the two parties. Are you a joint venture? Are you a partnership? Are you, are you two LLCs coming together for a one-time project? Are you two LLCs coming together to be a new business? So when a lot of those things are not defined, and even though you have this great one-time project. Oh, I'm sorry. I heard a echo. Even though you have a contract, that's a great start. You have a written contract. Always start with a written contract. But if you don't have an attorney that can explain to you what your rights and obligations and limitations are in that contract, you could be stepping into something that you don't know. You just don't know, and what you don't know, you don't know. But what I want to emphasize is that there are a variety of different ways that you can have a contract template reviewed by an attorney at a fraction of the cost. It depends on what you need. So for instance, a contract review can be as simple as, I have a contract. Can you review it and let me know if there's any clauses in here that I should be aware of that might be detrimental to me? And then the attorney would draft an opinion letter and say, you should be aware of X, Y, and Z. It's not favorable to you. A review could go an extra step, which would be, these are the clauses that are concerning. And the next step would be, here is what I would recommend that you change it to, or that you negotiate for, to make this a contract that is more favorable to you.
And not to interrupt you in the middle of that.
Sure.
It's so important that you do that, because there are so many instances where someone sends us a contract to sign, and we are so pressed to get the sale, or we are so pressed to get the partnership or the relationship, that we do not have somebody review it on our behalf.
Exactly. So, absolutely. Especially if you're talking about long-term projects or engagements that are worth a lot of money. Okay. Do not be cheap on the front end and lose your shirt on the back end because you didn't have someone review the contract. And now you're having problems getting paid because they have one word in the contract that said they must be satisfied with the, that let's say the quality control, they must be satisfied with the work before payment's done. But there's no description on what satisfied means. Satisfied is a subjective measure.
Yes, very vague.
Right. Very vague. There's no way to measure whether this person who is drafting the contract is going to be satisfied with your work, unless satisfied is defined and explained in the contract. And so just that one word, all of a sudden you can't get paid because you're being held up because someone's not satisfied. This one word pivot the whole contract.
So we were talking about earlier about service contracts and the importance of putting in there whether there are no refunds, right? And what the payment obligation is, right?
Payment terms and obligations, right?
The terms and obligations, right? And I went over the importance of having them have a clause, right? And for me, I do it 3 times, right? When you electronically sign our engagement agreement, right? I decide to take you on as a client. When you purchase my service, right? When you click that, here, this is the program that I want. There are no refunds, right? When you go to check out, there are no refunds. And when you go get a receipt, it says there are no refunds, right? So it's 3 places, right?
Right.
But I learned that from Dana, right? And listen, when you're using a merchant account, right? The importance of putting that contract, once that person electronically signs and agrees to purchase this service, right? Or this program, attaching that through there. And when I say, since I started doing that over a year ago, I've never had a chargeback.
Right.
They won't even call me. If you charge one of my merchants back, they are going to look up that contract that I've already attached, right?
Yep.
In my CRM. And they're going to be like, oh, she put it 3 times here, ma'am. There's nothing that we could do about it. And they're going to pick up the phone and call me like, Miss Sarah. And most likely, listen, if this is not for you, I'm the type of person that, here you go, here's your money back. But it's the principle for me. I've never gotten charged back since then.
Right. Don't come in my program and take my stuff and then trying to get out or get what you, right. We're not doing that because you've put those precautionary notes throughout the intake process.
Exactly.
So,
and I think it's super important for us to just throw those things out there ahead of time, right? It legally makes it does us a disservice if we don't. The transparency is key.
Absolutely. Listen. Transparency is key. With the contracts, I always ask my clients, do you have any questions about the contract? When you are presenting a client a contract, if there are particular terms that you want them to be aware of, because they are important to your process or they're important to you, to your relationship with the client, have a discussion about them. Pull the contract out when they're, typically now we are digital now. And so you send a link and they sign or whatever, what have you. But if you want to, you want to reiterate your return or no return policy. If you have your payment terms, you want to make sure that you're very clear on the payment terms and that there's no ambiguity. Any ambiguity that's in your contract, if it has to go to court, the judge is going to rule in favor of the not the drafter, but the recipient.
Exactly.
Because the drafter is responsible for there not being any ambiguities, being very clear. So if you have someone else read your contract, have a friend, someone else read your contract,
or call Dana and she will.
That's right. Or
she will review it for you. Like literally, have somebody who listen. Yeah. What I've learned is that everybody interprets contracts differently. So it's so important to have an attorney, someone who does this for a living, that's going to be on your side. And when I say, once you get that letter back with feedback, like you need to change these terms because it's unfavorable to you, you will be like, oh, this has changed my life forever.
Right. Well, right. You'll be like, I never thought of that. I hear that all the time. That never crossed my mind. Oh my goodness. That would have been a problem. Yeah, it would have been a problem. So taking the time to make sure that your contracts are airtight, that they meet, what the legal term is, all 4 corners of the document. You have your offer and acceptance. I remember you were talking about the elements that have to be in a contract, that there is consideration, and consideration is a fancy word for an exchange of something. So I am doing something for you and I'm going to get something in return, right? There always has to be consideration and mutual agreement. There has to be that this is a mutually agreed upon contract, and that's why you want to always have them in writing. Verbal contracts are valid contracts, but they are not as strong, and you can imagine the headache for trying to resolve a dispute that was verbally created, like a verbal agreement, and you're trying to work through, complicated issues that are not in writing. So, even if you think it's small, then draft something up, have something in writing. Give me a call, shoot me an email, say, I'm thinking about doing this. Is this something that I should have a contract for? And I'm probably going to tell you yes. If you think about almost everything is contractual that we do. When you drop off your dry cleaning, that's a contract. When they give you that receipt, that's a contract. They're saying to you, you're saying, hey, I'm going to pay you X amount of dollars to clean my laundry. That's a contract.
So let's go back into the basic elements, right? Because I think And I think those terms, and in order for it to be legally enforceable, right?
Yeah. Mm-hmm.
Yeah. The mutual assent, the
Right.
offer and acceptance, the consideration, and
capacity. They have to be at least 18.
And then the legality, right?
Right.
Retribution, right? If this happens to me, I can get this because I suffered in some form or manner.
And so that's called damages.
Yep.
So you'll typically see that in the contract as damages. If you breach this contract, right, breach a contract, then my damages are, recompense for, whatever your particular industry is, or however you want to be compensated if there is a breach of contract. So you definitely want to address what the damages are. And oftentimes you see where it'll say, if we have to litigate, it goes to arbitration first. You might want to consider having an arbitration clause in your contract so that you might avoid the expense of litigation. You start with an arbitrator. So that way, if they sue you, then you can reject the lawsuit and say, no, you agreed to mediation.
Okay. You put that in there ahead of time. And then what makes it voidable, right? Because I think sometimes what I've gotten is a lot of clients who get into a legally binding contract and you're like, how do I get out of this contract? So how can someone essentially, I think we lost you, Dana. You there?
Uh-oh, you did?
Well, I can't see your camera.
Okay. I'm sorry. Hold on. Let's see here. Okay. Well, essentially, wait, let's see what happened. Oh, yes. So in essence, contracts for a general matter really can't be voided. They can be breached. However, there are instances where they can be voided. If the contract was made in duress, if the contract was made and you were not of capacity, meaning perhaps you were intoxicated. If the contract was made and you are under the age of 18, that's a voidable contract. So that's why there's not many reasons that you can void fraud. I think you can void a contract if there's fraud involved.
One that I wanted to discuss particularly is one party's death, right? I think I've seen online quite a few things, and I did a podcast last week in concerns to the importance of having a beneficiary, right? Mm-hmm. Because oftentimes when we're running businesses or we go into a contract or agreement with someone, we do all of these things, and after years, they become very beneficial to us, right? Mm-hmm. But because we don't have a beneficiary, if something were to happen to me legally, like I die, I need to make sure that my family is still eating off of this. It doesn't void that contract.
Absolutely. Yeah. So one thing, I guess that's a pretty broad topic. I'm just trying to figure out where to start with that.
And listen, this is part one. Next week, we're going to be talking about trademark specifically. Okay. But I wanted to
touch on contracts.
Yeah, contracts is big here. Like I get so many boxes and concerns to contracts.
Absolutely. So when it comes to, I'm just trying to figure out with your question, I'm trying to narrow it down.
So specifically, I had a client who they passed away. Mm-hmm. Their spouse passed away. Mm-hmm. And the wife could not get access to the bank account, nor any of the property or the investment properties because she was not listed as a beneficiary. And basically it went into back to the court, and the court has to decide whether that is left to her
Yep.
or
She has to
two of his
apply.
children, which are under the age of 10. So most likely it would be her. But you never know. That judge might rule in favor of the thing. And she's like, Sarah, I've put all my blood, sweat, and tears into this. I am his partner. I was like, well, legally you're not, because on his paperwork, you're not listed. And and his bank account wasn't listed as a beneficiary. So like everything just gets stuck. I'm talking about hundreds of thousands of dollars.
Yeah. And I advise my clients who are self-employed, who have families, and that's their self-employment, whether it's a family business or, you know, they have a spouse or a partner that contributes to their, you know, the self-employment income. You have to have an estate plan. You have to have a will. You need a succession plan for your business, because anything can happen to you at any time. Unfortunately, that's the way life works. You could be headed to work and something tragically happen. You need to make sure that you have things in place so that your wife can pick up with at least the least amount of, you know, court and conflict in her life. Right? You know, it's already a devastating life traumatic event going on. Don't leave your loved ones in a position where they're going to be dealing with conflict in court when it really just could have been a simple matter of having proper documents in place.
And Dana does trust too, guys. So that's essentially what I was getting at. She is very good, and she specializes in trust. So keep in mind that you need to talk about, I know it's an uncomfortable situation, but death is real. And like Dana mentioned, you should definitely have a plan in place.
If you know that you are the breadwinner for your family and people are relying on, you know, you to be there to keep things going, have a plan in place in case something happens where you can't. Even, you know, you could become incapacitated. You might not be able to talk or make decisions. But I have an audit. I have a legal audit for your business. It's actually taps into 15 different places or areas of your business. And it is going to absolutely 100% identify where you have any gaps or holes in your business that need to be plugged. And it's something that you can work on throughout the year. You can pick a particular section of your business and work on that, a different one every month. One of the things, one of the sections that's in the audit has to deal with access to your records. Do you know the serial numbers for your equipment? If something happens, and one of the questions is, if something happens to you tomorrow, could someone walk into your office or log into your account and keep operations running the next day? Do you have that set up? If you do not, it is critical for you to, if your business is your livelihood. Now, if this is your side hustle, if this is something you do, you know, when you get home from work or you do on the weekends, then this is maybe not a top priority for you. But if your family lives and dies by the income that you bring in from your business, that you put all your blood, sweat, and tears into, you should have a will in place. You should have a business succession plan. And in particular, if you have partners, if you have a partner, if you have investors, they all need to know what is the plan, what happens if something happens to you. Yep. Don't leave your family members in court and conflict because you didn't take the time to make these decisions beforehand. Yep. It's like you said, Sarah, it's an uncomfortable topic, but it's really going to be uncomfortable if you're not around to help anymore. And think about the level of discomfort that your loved ones will feel when they can't even access $2 out of your account, but they know there's 200,000 in there.
Right. And that's exactly what what kind of situation she was in. I felt so bad because I'm like, listen, like,
you know, the money's there.
Anything in writing.
Yeah.
She needs to pay for a funeral.
Yep.
And
oh gosh, my heart.
Yeah. So,
and when you do not have when you, unfortunately, you know, when you don't have those things in place, when someone passes away, if there's no will in place, you have to go open up the estate. It's a whole entire process to start to probate an estate. And there's really, you don't know when you're going to have access to, money and funds and things of that nature. So if one of the things I would highly encourage your listeners to do is to reach out to me for a legal business audit. That way you can begin the process of identifying.
Is there a cost for that?
Yes, it is. It's $4.99.
Okay.
It's $4.99. It is, like I said, it covers 15 different areas of your business. And it's something that you can do on your own time, but it will walk you through all of the legal measures that you should be taking in your business. And it asks you, have you done this? What are your insurances like? What are the rates on your insurances? It really is just, it's an annual checkup. Once you do it, you'll realize where your gaps are and what things you need to work on in your business to protect yourself and your family.
No, I think like what you hit on is super important. I think sometimes oftentimes things get misconstrued and twisted around, and we forget about the importance of the legal side. We got 10 minutes left, and okay. I wanted to ask you some personal questions, right?
Okay.
Who is Dana Blue, right?
Yeah.
And how can we find you?
Oh, okay. All right. Well, I am, like Sarah mentioned, I am a business attorney, but my specialty is in trademarks and intellectual protection, protecting your passions and profits. I consider myself to be a brand builder, rights negotiator, but I work with entrepreneurs, creatives, empire builders, side hustlers, anyone who has a dream and that wants to make it into a reality. But I work with people who have huge visions. Really, they come in all forms and fashions. Like I said, entertainers, entrepreneurs, side hustlers. I work with people nationwide with their intellectual property,
which is so fitting for She Is Still Dope, right? Because we're a network of women who are visionaries and we don't know where to start. So for me, like it was when I talked to Dana. She's also my friend. She's became my friend. She's my attorney, but she's also my friend. And her testimony is so dope, right?
Yeah.
So Dana, right?
Yeah.
And just on the encouragement side, right?
Yeah.
I'm a manifester. I believe in goals. I'm a visionary. And for me, I'm not for everybody, and I'm okay with that, right?
Yes.
But when I met Dana, right, we built our relationship over years. But when I met Dana, I was very distant from her until she became my client, right? And then once she became my client and I learned more about her and I started spending time with her personally, what I love about Dana is her strive, right? She's a very, she's an empath. And for me, it was so fitting because her story touched my heart. So Dana failed her law exam how many times?
Well, so I didn't fail the law exam, but once I decided that I wanted to go to law school, I put together a 2-year plan. I thought I'm going to take the LSAT, then I'm going to apply to schools. It's going to take me about 2 years. It ended up taking 4 years because I was turned down 37 times before I got my
right? And listen, and just her not taking no for an answer, right?
Right. I was turned down 37 times before I got my first yes. And, my mindset was there's 264 law schools in this country. I've got another 230 to apply to, but it never crossed my mind that I was going to stop my mindset was, I just got to get to the yes. Someone's going to give me a yes. I just don't know which one. And what I realize is, and I think this is, I love sharing my story because I want people to realize there's always more than one way to skin a cat. And if something isn't working for you in one particular direction or strategy, change it. Because that's what it was for me. I had to think about it. And I said, why am I not? I mean, I think I'm pretty awesome, but for some reason, they're not seeing that on my application. And there's a couple of things that, I mean, there's some things I can change. There's some things I can't change. I can't change my GPA from undergrad. That's done. That's what it is. You know, my LSAT score. Now, I kept taking it, retaking it, taking it. I was only going up 1 point, 2 points, 3 points. Like, it was extremely frustrating. So I pretty much said, you know what? Can't change my LSAT score at this point. I've invested all the money. I've gotten all the books. It is what it is. I thought my essay was great. I thought my application was great. But what I realized is I was looking at who I was applying to, and I had limited myself. I limited myself to local law schools because I had an 8-year-old, and I thought, I can't, I need help. I need my parents. I need somebody around to help me, because how am I going to go to law school and do all this? And so I applied to schools that were within driving distance. And then I also realized that I'm also applying to schools. I'm in the Philadelphia metro area. Other applicants are probably just like me. They're probably single moms, Black female single mothers. They probably got the same story in their essays. We all want to change the world with social justice. Like, I needed to figure out what was going to make me stand out. What I realized is that I needed to apply to schools that did not have applicants like me, that did not see Black female applicants coming through their, applying. So I pulled that list of 264 law schools I had. I filtered out. I did a filter, and I figured out which law schools had the lowest minority enrollment. And when I started to apply to those schools, I got into every single one.
That part. but right? It's not how you look at things, right? But it's not losing your vision and looking at it from outside the box. Because oftentimes we box ourselves in on what we think should be the standard and not other people. So I just wanted to share.
Absolutely. I love sharing that story.
Yes.
And the icing on the cake for that, Sarah, was the first school that accepted me offered me a full tuition waiver.
But God, won't he do it? Won't he do it?
It's like after 37 schools told me no, I got a yes. And I got a yes with all the money I needed. Like, why does that happen, right?
Won't he do it? Won't he do it? So, no, I'm going to thank everybody for tuning in. Dana, thank you for being my guest today. I hope you guys have enjoyed Dana. Follow me every Friday, Bank on Women, on the She Is Still Dope Network TV, right? And if you haven't already joined She Is Still Dope, please do so. Dana will be on with me again next week. We're going to be talking about trademarking specifically and trust. Because I think those
trademarking areas. And you can find me. I don't think I dropped my website, but it's www.danabluelaw, DANABLUE law.com. You can find me on Instagram and Facebook with the same name, Dana Blue Law.
Yep. So we put it into the chat for everybody. And no, we definitely, again, we appreciate having you on. If you haven't been inspired by her story, like literally, it is definitely touching. Contact Dana directly for that business assessment, also, or that audit. And then also,
if you have contracts, if you got contracts sitting around and you're not so sure about it, you can, just reach out to me. Email me at info@Dana Blue Law. Any of your legal needs, call me and we'll talk about them.
Thank you, thank you, thank you. Okay, well, Dana, thank you for being on. I thank everybody for tuning in, and we'll see you next week. Bye, guys.
See ya.